All rise. The Court of Appeals, Division 1 is now in session.
You may be seated. Good morning. We are here today on our case number 1CA SA170059, Strength Training Incorporated versus Gerlach, the real party in interest being Mr. Betty. Counsel, as you know, each of you have 20 minutes for your argument. The petitioner may use any amount of time you'd like to use in rebuttal. You're in charge of keeping track of it. If you do, the clock on the podium will reflect the total amount of time you have remaining, including what you've decided to reserve. We record these proceedings. Both of you have been here so much. I feel like I'm just reciting this for turning on the button here. We record these proceedings, so please give us your name when you approach the podium and the name of your client. We've reviewed the filings and the record. We've also discussed the case in our conference. So with that, Ms. Gilbride, you may proceed.
Thank you, Your Honor. Eileen Gilbride for the defendant petitioner, STI. With me at counsel table is trial counsel Jay Rosenthal and Ken Januszewski, who is for the intervener, Westfield Insurance. I think we can agree there was a disclosure violation and not the all-state insignificant kind of disclosure violation and a finding of no good cause for missing the deadline. I think what we're really here to talk about is the sanction. If I'm wrong, I'll take questions on the first two issues, but otherwise I'll just get right to the court's question about which rules apply.
I think your colleague would say that there was not a good cause finding, as opposed to a finding of no good cause. But
right. He has said that in the pleadings, and we've said there was a good cause finding. You can read the minute entry that said there was no good cause or no good excuse, or whatever the language the court used was that the failure to disclose was not excused by the excuses he gave. So right. That to me is a good cause finding. If you would like to talk about that more, we can. Otherwise, I'll go on to which rules apply. And the answer is the 2016 rules apply, and I have three reasons. First, the plaintiff has never argued that the 2017 rules should apply.
But, we'll affirm if the trial court was correct for any reason. Even if it
right.
stumbled into the correct reason, it doesn't appear the 2017 rule was raised by anybody until we raised it.
That's absolutely correct. And you can affirm the trial judge for any reason, shown by the record, but not when there's a waiver, respectfully. The parties were operating on the basis of the 2016 rules. The trial judge was operating on the basis of the 2016 rules. There wasn't even an order to adopt the 2017 rules when all of the deadlines were set and expired with no disclosure here. So if the judge and the parties were all going on the basis of the 2016 rules, respectfully, I don't think it's fair or appropriate to say to the judge, okay, what you did was incorrect under the rules that everybody was going under, if that's what we're going to say. But if we go back in hindsight, we could retroactively say, but it was correct if we apply a different set of rules that nobody else was using. So I don't think that's appropriate, respectfully. So waiver, if you want to call it waiver, the fact of the matter is that everyone was operating under the 2016 rules. And this goes to the second reason the 2016 rules should apply, and it's
interrupt you and go back because
sure.
This is a special action, and so jurisdiction is highly discretionary. Why would we accept jurisdiction under this situation, waiver aside?
Because
we wouldn't write on it, because why are we going to write on 2016 rules when it seems like the 2017 version, with some procedural niceties aside, would allow this kind of order?
It would. The order implementing the 2017 rules do say that they apply to existing cases, except where it would be inappropriate or
that the court determines that applying the new rule would be work in injustice.
Injustice, right? Work in injustice, and we would say it would work in injustice here. And it would work an injustice because everyone, especially defendant, was operating under the assumption and the expectation that the 2016 rules were applying. There weren't even 2017 rules. The order hadn't even come down at the time the rules were set. The deadlines were set. The expert deadline was blown. The discovery deadline expired. When the discovery deadline expired, that was in August of 2016, there wasn't even an order implementing any new rules yet.
I totally agree with you. I think that if the focus here were on the disclosure violation itself as opposed to the court order, you'd have a much more compelling argument about why the old rule applied, and you'd have a really good argument under the old rule. But with the focus being whether the Superior Court erred as a matter of law, abused its discretion, however we characterize it, I guess abuse of discretion in the special action context, I'm having more difficulty with the 2017 issue.
With why the 2017 doesn't apply?
Yes.
Because, okay, so first is the waiver. Well, if you want to call it waiver, the fact is that everyone, even the trial judge, was going under the 2016 rules. The second is that the defense it created its defense, it formulated its theories, it decided what evidence, what witnesses to have, what crosses it was going to do. Its entire focus of its defense was based on the assumption that if evidence or witnesses were not disclosed, they were not going to be used. So the whole idea of the disclosure rules is so that the parties know exactly what the other side is going to have and that they can, create their defense on that basis. And that's how STI created its defense, on the whole basis of if it wasn't disclosed by April, there wasn't going to be that kind of an expert, they were going to have a human factors expert, which is fine, and we'll create our defense on that basis.
Is that an argument that you made to the Superior Court judge, that trial counsel made to the Superior Court judge?
Yes.
And reading the order, it seems to me that the court was very accommodating to the defense's interests. I mean, but for allowing the disclosure, the court said, "What do you need?" Effectively said, "What do you need because of this?"
Well, yes. I mean, and that's the other side's argument, is that we, being the other side, have to pay all this money for you to get a new expert and to, oppose the new Dr. Paulus. But the fact of the matter is, it's more than just paying for the rebuttal expert. The defense now has to reshift its focus of its theories. It has to decide, are we going to need other experts, or not experts, other witnesses? Are we going to have to ask them different questions? Are we going to need new documentary evidence? Do we need to reformulate our cross-examinations, our direct examinations? It's not just paying for Dr. Paulus. The whole reason for having these rules is so that we can do this as we're going along and make the discovery and the litigation more efficient and direct. And that's exactly why you have the rules. If we now are going to allow them to say, oh, sure, you can violate the rules by a long time, 8 months, and just pay for this other expert, it's fine. You just undermine the whole purpose of the whole rules. And it does prejudice the defense, because we've focused our defense on a certain theory, and now we have to refocus on a different theory, which requires more work, maybe a different witnesses, questions, cross-examinations, documentary evidence. This is a whole new theory.
That's a good argument.
Thank you.
But you knew there was a but coming.
Yeah.
But isn't that an argument that's defeated entirely by the 2017 amendment, which allows the court to say, I don't care about all that. I'm going to make sure that you're compensated, but I'm going to allow the disclosure?
If there had been good cause, maybe. But the court found no good cause. What you're saying now, if we do interpret the 2017 rule, which again, I don't think should apply, but if we're going to apply it, if you're going to apply the 2017 rule and interpret it to say, okay, other side, go ahead and violate the expert disclosure deadline by 8 months. Go ahead and blow the discovery deadline by a couple months. You can have whatever new experts you want as long as you just pay for it. You've just undermined the entire reason for having disclosure deadlines.
But arguably,
Isn't that just one of the sanctions? I mean, it's not something that Judge Gerlach has to go to. That's something he did do, but he could still preclude the witnesses. Isn't that correct under the rules still? 16 or 17, or just say 17?
After he's denied our motion to preclude, he's already denied our motion to preclude, saying, no, I'm not going to preclude. You can testify as long as you pay us.
No, I was asking you more. You're saying that now you can basically buy your way out of a disclosure
Right.
Violation, but that's just one of the options to the trial court, correct?
Right. Trial judges, under the new rules, can preclude or they cannot, apparently, or do whatever they want, which means there's basically no rule at all. What litigants are going to see is like, oh, well, I guess I can violate the rule, no big deal, and
well, and that's where I was going to jump in. I mean, I might agree with you as a policy matter that's bad policy, but if we're talking about what the rule says, and again, I think you had a really good argument, have a really good argument under the 2016 version. But I think if we're going to talk about what a rule says, then the new rule, 2017, instead of sanctions, the court, on motion after giving an opportunity to be heard, may order payment. I mean, the rule allows it. It may be bad policy. I may not agree with it, but if we're talking about what rules say, that's what it says. The other thing, though, it does give a few more options to the trial judge. For example, informing the jury of the party's failure.
Right.
That's new.
Can I go back for a second?
Sure.
I don't mean to interrupt. I apologize, because you're reading off of 37C3.
Correct.
37C1, if I can point this out. 37C1 actually changes, if you're lexicographers like we like to be,
Right, yes.
it changes because it says the party may not. Okay, the party may not use the information. To me, that says, that's the may not is permissive. You may or you may not. It's not that you, what am I trying to say? It's not the court may not. The old rule said the court shall not permit someone to use. The new rule says, party, you may not. That to me says, you can't. This is not a discretionary use of the word may. It's a permitted or not permitted use of the word may.
Well, I get that, but doesn't the first clause of C1, isn't that first clause implicated here? That clause says, unless the court orders otherwise for good cause.
Right.
Did the court in this case make a finding of good cause for its ruling? It didn't.
It did not. It found no good cause, and I use that term, for the failure to timely disclose, and it did not find good cause to avoid the rule.
And those are two separate things.
Those are two
I
separate
think.
things. And neither of those, both of those are missing here. That is where, if the court has discretion, that's where it comes in.
Yeah. Well, and then in choosing the remedy, I mean, if it, under C3.
So if I can go back again, if you're looking at the language of C3, that language was in Rule 37. It has always been in Rule 37. It was in Rule 37 back in 1993 when Jones versus Buchanan came down. It was in Rule 37C when Allstate came down. It was in Rule 37C in 2016. And it's in Rule 37C now. It has been the same language all the way along. The fact that it's broken out into a different subsection now for clarity doesn't mean that the substance has changed. It's always been there, and the rule has always been, you shall not use unless good cause.
Well, but then you wouldn't need 3. I mean, 3 says instead of the sanctions under 37C1, the sanction under 37C1 is may not use. And so C3 has to mean that the court can, instead of preclusion, do these things.
But if it means that, it meant that in 1993 when Jones versus Buchanan came out.
Well, but the language of the old rule didn't track the new C3 language that we're talking about. It talked about, in addition to requiring payment of reasonable expenses cause of failure, sanctions may include any of the actions authorized. I don't read it as being the same when it comes to C3. I agree with you on C1, basically.
C3, the only thing that C3 adds now that it didn't have before 2017 was using 37C1, was identifying 37C1. What it had before, and I don't think this was an intentional huge substantive change that the task force intended to do, because there's nothing in the task force minutes that talks about this. In addition to language before 2017, it followed a second sentence in between, you shall not preclude. The second sentence said, if the party inaccurately or incompletely discloses, you will pay the other side's, expenses for having to investigate. In addition to or in lieu of, if we're using the last antecedent rule, you do these other sanctions for people who incompletely or inaccurately disclose. That's what the language meant in 37C before 2017. Now they've changed it, they've split it out, and they've made this C change from you shall preclude. Why even say you shall preclude or even may preclude? Why even use that? If the rule allows the judge to do whatever the heck he wants, why even say you may be party you may not use? It says C1 says party you may not use. It doesn't say court you may or may not preclude. It says party you may not use. That's a 2017 version. That to me says party you may not use. Now, it doesn't make any sense to me why later, a couple of sentences down, Judge, you can do anything you want.
Well, unless the court finds good cause. I mean, the party may not use unless the court orders otherwise. If the 2717 rule applies here, is the order defective because it lacks a good cause finding?
The sanction is defective because there's no good cause. The sanction is defective. Under the 2016 rule, which should apply because that is the rule that was in effect when the deadlines were set, when the deadlines were missed, when our motion was filed, and when the response was filed to our motion, did not raise the fact that they thought the 2017 rules applied. Everybody, even after January 1st, the response was filed, the order came down, everyone was going under the 2016 rule. Why? Because it was fair. Everybody was operating under that rule the entire litigation. The defense was creating their defense and formulating their theories and coming up with their witnesses and coming up with their exhibits, knowing that they would have to respond to only those evidence and witnesses that were disclosed. And that's what the judge ruled on. And I don't think we should go back and tell the judge, you were all operating under the rule that said shall, but we can go back and retroactively make it okay under a different set of rules that nobody was operating under. I'd like to save the rest of my time for rebuttal.
Mr. Abney.
May it please the court, pardon me, I have more papers to shuffle than I usually do. My name is David Abney, representing the respondent. I'm here today with Megan St. Thomas. At the start, my distinguished colleague said that something to the effect of that we all, quote, agree there was a finding of no good cause, and then several times during her argument she said things like, quote, it found no good cause, end quote, and, quote, the court found no good cause, end quote. The court made no finding of that there was no good cause. Went through the transcript very carefully on that issue.
But the court also didn't find good cause.
Not specifically. In fact, I don't think good cause appeared in the transcript anywhere, as far as I could tell by electronic search, as far as anything the judge said.
I agree the magic words weren't used, but I don't think that's your strongest argument.
No, my trump card is the language in Rule 37C3. Suppose that under 37C1, the trial judge said, well, I find no good cause. And it says here, this witness may not be used, and so, but I don't like that sanction. I think the sanction that really is appropriate is the one that I'm allowed to do instead of that may not use, that you can instead do what he did under 3A, which was order payment of reasonable expenses. It was very generous about that. I mean, it's basically they get a free shot at the expert. They get lots of things subsidized to do that.
Is there any indication he was operating under the 2017 rule, or that anyone in the case was?
I assume, and pardon me for saying that because I know that gets me in trouble instantly, but I assume that everybody was operating under the 2017 rule, which went into effect January 1st. The order from the Arizona Supreme Court was filed September 2nd, 2016.
Nobody mentioned it. Did you mention it in your response to the special
No,
petition?
I
Say everybody was operating. I think everybody backed into a result that may be validated by the 2017 rule.
Well, just because you don't know about a rule doesn't mean you're not operating under it. Everybody, because I've been caught a couple times by the rule change. I didn't realize that things changed, like the page limits and all these other things, wacky things I never even think of. Until I actually go back and look at the rule again, and there it is. It's been changed, and it's my fault. It's my fault for not realizing that all this stuff has been changed. And I've since gone back and looked at all the rules, and there are just a whole bunch of interesting and fun changes. But everybody was operating under this. They may not have been on their conscious mind, but like it or not, they were operating under that. And in fact, the September 2, 2016 order from the Arizona Supreme Court says that the rules apply in all actions filed on or after January 1st, 2017, or in all other actions pending on January 1st, 2017, except to the extent that the court in an affected action determines that applying the rule or amendment would be infeasible or work an injustice, in which event the former rule of procedure applies. But the
Should
court
we remand for Judge Gerlach to determine whether it is fair and equitable, or whatever the language is, or would work an injustice to apply the 2017 rule?
No, Your Honor, because the Supreme Court's rule applies unless there has been a finding, a determination that applying the rule would be infeasible or work an injustice. And there was no such finding, therefore the rule applied.
Well, there was no such finding because nobody talked about the 2017 rule. And trial judges are brilliant. Two of us up here fall into that category. And Judge Johnson, had she been a trial judge, would have been off the charts brilliant. But nobody talked about the 2017 rule. So at a minimum, shouldn't we send it back to Judge Gerlach and say, hey, you might have gotten it right by applying the 2017 rule, but you need to make this finding? I don't know. Is that a possibility?
I would be a fool not to admit that possibility to such a distinguished jurist. But I don't really think that it's necessarily a proper way to go, given the language in the Supreme Court's rule. And it's not as if, and I feel silly about this myself, every time I get caught by these new rules, every time I did get caught, I hope it doesn't happen again, because there was a lot of hoopla about them. I attended a couple seminars concerning them, and some parts I just must have tuned out. And it was in the Arizona Attorneys. There were a number of articles in the Arizona Attorney. There was a whole lot of advance notice that the rules were changing as of January 1st, 2017. So these folks either knew, or the classic formulation, they should have known what the rule was that they were operating under. And really the language there takes care of this problem, because it gives the trial judge an enormous amount of discretion, even if he had said, I find no good cause, which didn't happen. then the trial judge can still say, okay, I think it's wrong just to completely cut out this witness or this information from the witness. And instead of doing that, plaintiff, have a nice day. You have a big check to pay here. You've got to pay for all these things, your expert and preparation, all these other things. So I thought it was a very creative solution and very comprehensive.
Is your client fighting that after the fact?
No.
There's something in the record indicating that there's some attempt to get Judge Gerlach to backtrack on that. And
No.
Okay.
What there was a motion for clarification. Do you really mean that they get a new expert, or is it enough that the expert that they have will cover that if you pay the expenses? And they were very polite and deferential in making the request because they didn't want to step into the bear trap of saying that they were opposing this order, because they're not opposing the order. They're standing ready to pay, even though it's going to be a costly bill. But it was a good solution to a difficult problem.
In a case to which the 2017 rule applies, before the court may allow the untimely disclosure, does the court need to make a finding of good cause? And again, I'm not good cause for the party's failure to disclose before, but a good cause for what the court is ordering.
I think that might be what you call preferred practice. I think that may be a good idea, but I don't think it's mandatory. I mean, the cases, you're more familiar with it than I am, but there's a lot of deference given to trial judges, and if they don't get around to saying so-and-so is my reasoning, or that normally doesn't apply. Unless somebody has asked for a specific findings of fact and conclusions of law. But in general, the trial judge gets to operate and make the decisions and doesn't have to explain exactly what happened. And the court presumes, the same way it does with jurors, that the trial judge is applying the law and doing the best thing possible. And here, you can't explain. Well, I guess you could say he made a finding of no good cause. This is a hypothetical. Hypothetically, if he had made a finding of no good cause, he could still do what he did, which was to instead of
under
excluding.
the new rule. I'm not sure under the old rule.
Maybe not, maybe yes, maybe not. Shall is a real slippery word. If you take a look at Garner's modern American usage or legal terms, there's about 8 different definitions of what shall means, all the way from a very permissive may to a very emphatic must. So, I mean, it's hard to know. I think that's one reason shall is been largely vacuumed from the rules. It's basically gone. In fact, one of the articles about the rules in the Arizona Attorney, there was specific mention that they had a direction to get rid of all the shalls. They left one somewhere in Rule 56. I didn't go bother to double check on that, but in the article that Judge Swan wrote, he said, in Rule 56 we left a shall, but all the others were changed to may or must or some other term. So, but yeah, the language in 37C3 really does take care of the problem. But if you go back, and even under the 2016 version, it still has the escape hatch there of in lieu of or instead. I think they used in lieu, French word for meaning instead, I think. But if you actually go back to the State Bar Committee notes to the 1996 and 1997 amendments, which have been vacuumed out of the rule book for some reason also, to shift focus a little bit, it talks about harmless, whether it's a harmless problem for the other side. And it has a very nice, succinct definition. Harmless means the other party has a full and fair opportunity to investigate and rebut the new evidence. Full and fair opportunity to investigate and rebut the new evidence. And they have a subsidized full and fair opportunity to rebut the new evidence. I could go on. I love talking with all of you, but I think I've made my points. If there's any questions.
No, I think we're good. Thank you.
Thank you, Hunter. Thank you very much.
I just have 4 short points to make, hopefully in 2 minutes. First, counsel's argument demonstrates why the 2016 rule should apply. No one raised or thought about applying the 2017 rules. No one. Second, it's not as if the plaintiff's case goes away. They have a human factors expert. They have all their other evidence. They have all their other witnesses. If they can't use Dr. Paulus, they can't use Dr. Paulus. They'll have their human factors expert testify to whatever he testifies to. But, so it's not like this is a big dismissal. It's aside the fact that they've already settled the medical malpractice part of the case. Third, counsel spoke of the word harmless in the comments to the 1997 rules. What the comments say is that we are codifying Allstate versus O'Toole. The harmless missed deadline in Allstate was someone missed an initial disclosure deadline by a couple of weeks. That's not this kind of error. This kind of disclosure problem is not a harmless one. And finally, to go back to your question, Judge Downey, about why take jurisdiction to apply the 2016 rules, because the court made an error of law in ordering a sanction without any finding of good cause. And that's just wrong. Even if you don't write an opinion to talk about the 2017 rules, we're here, it's been briefed, you're familiar with the case, we've argued it, and it should be corrected. Thank you.
Thank you. Thank you to both sets of lawyers for your briefing and your arguments. We'll take that matter under advisement and issue a decision in due course. Oh, and now we'll recess for a bit.